and I'm going to hand over to Ed if that's okay.
Thanks, Martha. Morning, everyone. Thanks for coming along this morning. I'll just share my screen and check that that's all working for you. It worked in the test. So is that all? Is that showing all right, Martha? Brilliant. Great. Thank you. Yeah. Obviously a very hot topic at the moment. Having a look at sponsorship duties and immigration changes. It's going to be a really informal session today. So if you do have any questions as we go through, please do raise your hand, and I'm happy to deal with those as we get to them. Um,
Vicky, we are
Otherwise, there
interested.
is chance for a Q&A at the end. So if
Hi,
there's
good
anything
morning,
you want
Vicky.
to
I'm in a
ask.
meeting. Are you okay?
Oh, I think someone's just off of mute. If you wouldn't mind muting yourselves when you're not asking a question, that'd be appreciated, and it'll keep disruptions to a minimum there. Um, but yeah, as I say, we're going to be having a look at sponsorship duties and immigration changes. If you don't know me, I'm Edward. I'm a solicitor with Leicester Aldridge. We're a firm that specialises in acting for adult social care providers. And deal with all aspects of legal support there. I specialise in employment and immigration law myself. So what we're going to be having a look at today is we're going to have a review of the recent changes because, as was being discussed just before we all joined, it keeps changing all the time. There are constantly new rules being tweaked and introduced, so it's always good to have a recap of those. So we'll have a look at those. We're going to have a look at other changes and upcoming changes, other than the key recent ones, because again, there are going to be some changes coming up in the next few months that you're going to need to be aware of and preparing for. We'll then have a look at generally your sponsorship duties, what you need to be doing as a sponsor in order to comply with your obligations. Um, we'll have a look at certificates of sponsorship because, as we'll see, the rules have changed in relation to applying for those. So have a look at what you'll need to do when you're applying for certificates. Now, right to work as well. That's another obligation that you need to undertake, and it's something we see problems with when we're running the SESCA helpline. So SESCA is the South East Social Care Alliance. We run an international recruitment helpline for care providers for them, and we see a lot of questions about right to work through that. And then finally, compliance visits. We know that there's been a huge spike in compliance visits and revocations at the moment. So this will be a few tips to help you prepare for those, and try obviously to avoid having your license revoked. Perfect. Well, that takes us on to the recent changes then. So very recent, we had changes announced last week. So these were announced on the 5th of March and fell under the Statement of Changes in Immigration Rules HC 1691. So there were various changes affecting several routes on immigration. The main ones that are going to be applicable to you with sponsored workers in the care sector are these following ones. So the sort of headline was that there's a change in the way that salary thresholds are being measured. So this is where you're showing UKVI that you're meeting the pay threshold that a sponsored worker should be receiving from you. Now, the way that these are going to be measured moving forward is that where you have a pay period of a frequency of 1 month or less, so that'll be most of you, I presume. You'll probably pay on a monthly basis, so you'd fall into this category. That'll be measured over a 3 month period. So essentially, you'll need to show that the salary threshold is being met over a period of 3 month reference periods. So every 3 months that the salary threshold is being met. So if there's a dip in 1 month over the next 2 months or 2 months surrounding that, you will need to show that it's been exceeded so that overall the average meets the threshold. For pay periods of a frequency greater than a month, so if you're paying, say, weekly or twice or bi-weekly, that'll be measured over a 12-week period. So again, over a period of 12 weeks, you'll need to show that the threshold is being met on average. And then where regular pay fluctuates from month to month. So this will generally be for domiciliary care providers where there is a degree of fluctuation. This is permitted, but over a 17-week reference period, that's the period that you'll need to show that the salary thresholds are being exceeded. So those are the periods that you're going to have to bear in mind when it comes to making sure that you're paying your sponsored workers correctly. And that's really important, as we're going to see in a bit, because where pay thresholds are not being met, we're now seeing that resulting in an instant license revocation rather than a suspension first. So really important that you're complying with that. There was also a change regarding the increased requirements on settlement. So when a worker applies for indefinite leave to remain, currently the English language requirement is at a level B1 level. That's going to increase to a B2 level from the 26th of March 2027. So again, it's going to be more difficult for workers to qualify for indefinite leave to remain because of this. Now, going back to October, there were other changes announced. They weren't hugely impactful on the care sector, but I'm just going to have a look at some of the ones that were more important. There was a change to graduate visas, which is going to apply from January next year. These are going to be reduced from 2-year visas down to 18 months for most. So if you do have graduates on the books, or you do take graduates on the books with graduate visas, you just need to bear in mind that those are for a shorter period from that date. Again, different English language requirements. This is for new people being sponsored rather than those applying for indefinite leave to remain. But for new people being sponsored from overseas, again, the level is raised to level B2. It's not something you're going to need to be particularly worried about, because for care workers and senior care workers, obviously you can't recruit directly from overseas anymore. But if you do recruit directly from overseas for other roles, you just need to be aware of that increased requirement. The immigration skills charge that increased last year, so that went up by 32%. That was partly to deal with inflation and partly to encourage a reduced reliance on overseas recruitment. And what that meant was that for small employers, that increased from £364 to £480 a year. And for medium and large employers, from £1,000 to £1,320. So obviously over, say, a 5-year visa where you're paying that up front, it is a substantial increase to take account. It's obviously something you need to budget for when you're planning for international recruitment and the costs of that going forward. And then we've had the settlement consultation, so we're going to have a look at that in a bit more detail, because that is sort of ongoing. The consultation is finished, and they're making a decision on that. So just going back to July, I'm sure you're all au fait with those changes now, because we've had them in place for a little while. But essentially, these were the major changes for the care sector. So essentially, under these changes, new entrants to the care worker and senior care worker roles are no longer eligible for sponsorship. So these are for people moving from one visa to one skilled worker visa to another skilled worker visa. You can't move into a care worker or senior care worker role if you hold a skilled worker visa already and you're not already on that track. There is a transition period in place. So that lasts from the 22nd of July 2025 to the 22nd of July 2028. And during that period, those on the care worker or senior care worker visas, they'll be able to continue to be sponsored under those visas. So they can move to new sponsors. They can apply to renew their visas during that period, so they can stay on that route. And also during the transition period, it's also possible to move from other visa routes onto the skilled worker route as a care worker or a senior care worker. So if you're moving from a student visa or a graduate visa or a dependent visa, you're still able to be sponsored as a care worker or a senior care worker. There is an additional requirement if you're moving to a different visa. That's that you should have worked for the provider for at least 3 months before the certificate of sponsorship is assigned to the individual. So if someone's moving from a student or graduate visa, they'll need to work for you for 3 months and then you can sign the certificate. Just important to note that if they are already sponsored as a care worker or a senior care worker prior to the 22nd of July, even if it's for another provider, they don't need to have worked for you for 3 months before you assign the certificate. They can be assigned that straight away. Now, at the end of the transition period, from the 22nd of July 2028, the care worker and senior care worker roles will remain on the eligible occupation list at the moment under the current plans, but the intention is to remove these roles from the immigration salary list and temporary shortage list. So what that means in practice is that the relaxed requirements for sponsorship under those routes, which notably for you is the reduction to the minimum salary threshold from the current tier 2 salary threshold of 41,700 a year down to 25,000 a year, which those roles currently benefit from, that's going to be removed. So essentially, when you're sponsoring someone or assigning them a certificate of sponsorship after the 22nd of July 2028, the current plan is that you're going to need to be paying that individual at least 41,700 or whatever the threshold will be by the time we get round to that. So obviously for most providers, that's not going to be financially viable. So you need to be essentially, well, planning for these rules to be in place. You're going to need a contingency plan where you're not relying on international recruitment because you're not able to. But in the meantime, Westvic and Seska, I know, are engaging with the government, lobbying the government to try and persuade them that these rules aren't going to work in practice. So it's going to be a case of continuing to do that, engaging with your local MP to try and get the government to change its mind in the meantime. And the final change that was announced was that there's no longer a requirement to engage with the pool of displaced workers before you assign a certificate of sponsorship. So that was announced that requirement was brought in April 2025, but was then removed in July. So no need to engage with that pool before assigning a certificate of sponsorship. The displaced worker pools do still exist and are still a useful resource for you to recruit from because you've obviously got a ready supply of recruits there available for you. But it's no longer a requirement. So if someone approaches you directly and they're suitable for a role, you can go ahead and assign them a certificate without them having to go through the displaced worker pool. Now, the other changes that you're going to need to note that are coming up, notably, is the proposals for earned settlement, the changes here. So what the government has announced following the white paper last year was that they're intending to increase the qualifying period for indefinite leave to remain from 5 years up to 10 years. For those falling below RQF level 6, so that includes care worker and senior care worker roles, the intention is to increase that to 15 years. So essentially, someone needs to have been working and sponsored for 15 years before they're able to go ahead and apply for indefinite leave to remain. So you'll appreciate that's a huge increase, trebling the amount of time. And obviously, when combined with the proposed changes to increase the salary threshold post July 2028, it means a lot of care workers are not going to be able to qualify for indefinite leave to remain because they're not going to get to the 15 years because you're not going to be able to afford to sponsor them for that long. So they are going to be left in the position where they're going to have to return home if all these changes.
Yeah. What did they on?
Did someone have a question? They've just come off mute. No, okay, that's fine. So, yeah, obviously major ramifications here if these rules do come into place. Um, Another change that is being considered as well as this, which has perhaps not got so much press, is that there's going to be a change to the no recourse of public funds condition at settlement. So at the moment, those under care worker and senior care worker visas, they have a no recourse to public funds condition under their visa. So whilst they're sponsored, whilst they're under a visa, they don't get access to public funds. When they qualify for indefinite leave to remain, that changes. They do. They're on the same sort of access to public funds that everyone has. If these rules or rule changes are adopted, that means that even after they qualify for indefinite leave to remain and they're settled, they still have no recourse to public funds. So they still have no public support, etc., etc. So makes it more difficult to settle into the country and introduces a two-tier system, which is really difficult for care workers. Also, there's going to be additional hoops to jump through to qualify for indefinite leave to remain. So at the moment, you just need to show that you've got time to count to qualify. Moving forward, if these rules change, migrants will need to demonstrate good conduct, contribution to society, and integration into society as well. So more hoops to jump through, more difficulty to qualify for indefinite leave to remain. The consultation period for this finished on the 12th of February, so hopefully you contributed to that. If you haven't, I think there's still resources available for you to write to your MP, such as template letters and that sort of thing, to make your MP aware of why these changes aren't going to work. So good idea to send that if you've not already done so. But the government has said that the planned implementation for these changes is in spring this year. So probably this month or next month that you will hear about this and whether this is being adopted. So something for you to be looking out for. All you can really do in the meantime is that if you've got someone who's got 5 years or has qualified for indefinite leave to remain, then encourage them to be making the application now, because if the new rules come in and they haven't done that, it's likely that they'll then need the 15 years before they're able to apply. The other change that's coming into play soon is the increase to national minimum wage. That's increasing to £12.71 an hour from April 2026. So you'll need to make sure that everyone, all your sponsored workers, are being paid at least £12.71 an hour. There will likely also be an increase to the sponsorship salary threshold. We see that generally each year, so I expect it to be the same this year. That's not been announced yet, but based on previous year increases, I'm expecting that to be around 13.50. So for anyone that you're assigning a certificate of sponsorship to after, it's usually the 9th of April 2026, that rate will apply. So you'll need to budget for paying them around 13.50 an hour. And then finally, to note, the post-license priority service fee has also increased. So if you're lucky enough to be able to get on that, I know it's very difficult these days to be able to get on that, but if you do get on that, you just need to note that the fee for that is increased from 200 to 350. So again, more things that are making it more expensive to recruit international workers. Right, well, that deals with the changes then. So we'll move now on to your sponsorship duties and a bit of a review. I'm sure a lot of this will be old news to everyone, but always worth a recap just in case. So essentially, your duties as a sponsor, they begin on the day that you're granted your sponsorship license and end on the day that that license is either surrendered or revoked by UKVI. However, UKVI can take into account actions that you've undertaken both before and after the license was granted when deciding whether to allow you to keep your license or to allow you to reapply if you are reapplying for a license. And your responsibility for each worker begins on the day that they're assigned a COS. And it finishes on the date that either you withdraw their COS, UKVI cancels it, their permission expires unless you've offered them a new COS, that they leave the UK and their permission lapses, or for whatever reason, you tell UKVI that you've stopped sponsoring the worker. Now, your responsibilities to workers is as follows. You need to pay them the minimum salary required for sponsorship. So that's either the sponsorship threshold or national minimum wage, whichever applies to them, whichever is essentially if the sponsorship threshold applies, that'll apply from the 9th of April, usually each year. If their role is paid at an hourly rate, you should be providing them with sufficient hours of work to be able to meet that salary threshold. You also need to check that they have the necessary skills, qualifications, and professional accreditations to do their job and keep copies of those documents, to only allow them to undertake the roles permitted by the conditions of their stay on their visa, to only allow certificates of sponsorship to be assigned to workers if you believe that they meet the immigration requirements for the role, and to tell UKVI if a worker isn't complying with conditions of their visa. So in order to do that, you're going to have suitable monitoring systems in place. So you should have an HR monitoring system in place that allows you to monitor your employee's immigration status, to keep copies of relevant documents for each employee, so that it will potentially include their passport and right to work checks, to track and record their attendance and working time so that you can report if there are any changes to this, to keep employee contact details up to date, so that you can contact them at short notice if necessary, and also report if there's any change of their address, and also report to UKVI if there's any problems, such as if someone stops coming to work, that is flagged to you. You're also under a duty to report significant changes in your business, and these changes need to be reported within 20 working days. So, for example, if you stop trading or become insolvent, if you substantially change the nature of your business, if you're involved in a merger or a takeover, and that's the one that is often missed, if you make changes that affect your relationship with any overseas business that has sent workers to you, that's less applicable to you now in the care sector. And if you make any changes to contracts covering secondment workers or service suppliers, then you need to report those changes via the sponsorship management system. You also need to tell UKVI if you're changing any of your details, such as your address or allocated roles, level 1 users, etc. You need to make sure that that's updated. Again, that's often missed when providers say are changing someone who's supporting them with sponsorship. Often I'll see those details left on the sponsorship management system. So focusing on changes of ownership, this is a real problem, and we're seeing this resulting in sponsorship licenses being revoked increasingly at the moment. So just worth highlighting for you. So you do need to report where there is a direct change of beneficial ownership in your business. So that can happen if your business is sold, if there's a share sale, or if there's any other change in ownership, such as a new holding company being introduced. If any of this happens, this is something you need to be reporting. So you need to report this change within 20 working days of it happening. And also you'll need to apply for a new sponsorship license. This triggers that requirement. So yes, if there has been any changes to your business structure, it's likely that you may well need to apply for a new license as a result. And what UKVI are doing, they're increasingly checking Companies House for any care providers who have reported any changes in ownership, and are then revoking those companies' licenses if it's not been reported. So really important that you deal with this if it has happened. And as I say, commonly missed by sponsors, we are seeing a lot of revocations in relation to this. So then when it comes to your sponsored staff, you've also got duties to report changes affecting them. So you have a responsibility to tell UKVI if there's any changes affecting your sponsored workers, and you need to be reporting these changes within 10 working days. So really not a lot of time to be reporting these changes. So that's really why it's important to have a robust HR system that flags these issues to you as a matter of urgency if they're happening. So the changes that you need to report are if there's a delay in the start date of the sponsored worker of over 28 days. So if you've had to put that start date back for whatever reason, you need to report that. If they fail to start work at all, if they're absent for more than 10 consecutive days without permission, so that wouldn't necessarily be sickness absence or something like that. This is unauthorized absence where they've not reported why they're absent. If a sponsored worker has been absent or on reduced pay for more than 4 weeks in total during a calendar year, so that can either be during one period or cumulatively. So that would cover things such as sickness absence or family-friendly leave, such as maternity leave, etc. If that's the case, you do need to report that if that ticks over for 4 weeks. So that needs to be monitored. If they no longer work for you, you need to report that their employment has ended. If you've made any significant changes to the terms of their employment, such as their job title, core duties, salary, or working hours, notably, it's only a decrease in salary that you need to report. You don't need to report an increase in salary. If their location of work has changed, if they're affected by a TUPE transfer, so if they're moving to a new employer by TUPE, or for whatever reason you've stopped sponsoring them, you need to all be reporting all of these things within 10 working days of that event happening. So that deals with your duties. We'll move on to certificates of sponsorship now, because as I say, that is another area that we see issues with from providers. So just again, a brief recap. I'm sure you're all au fait with this, but certificates of sponsorship are required for each migrant worker that you're sponsoring, and it provides the unique reference number that a sponsored worker needs to go away and apply for their visa. So the purpose of the certificate of sponsorship is for the sponsor to confirm that you intend to sponsor the worker, to confirm that you're satisfied that the individual can meet the relevant requirements for the role that they're being sponsored for, that you're eligible to sponsor the worker, and that you're agreeing to abide by the terms and conditions of sponsorship. So that's why you have to tick that box at the end of that form when you're assigning the certificate of sponsorship. That's to agree by the terms and conditions of sponsorship. And just a note, a valid certificate of sponsorship does not guarantee that the individual will be granted entry clearance. Just because you've assigned someone a certificate doesn't mean that they then have necessarily a valid visa from that point. It may well be that for whatever reason, the visa application is declined. So you still have to bear in mind that you've got to check their right to work during that period. If they are working whilst they've got an ongoing visa application, you'll do an employer's checking service check. But it is important to do that and not just assume that they all have the right to work because you've assigned them a valid certificate of sponsorship. Now, just to note, we've got the transitional rules which were announced as we covered before in July and during the transitional period that's running till July 2028. Now, because of those change of rules, there are additional things that you need to add when you're applying for your allocation of certificates of sponsorship in the year. So what you need to do now to be granted a certificate of sponsorship is you need to confirm that the transitional skills threshold is met for that particular individual that you're going to be assigning the certificate to. So that is either that the individual was sponsored as a care worker or a senior care worker prior to the 22nd of July 2025 and has held permission, continuous permission since, or that they're moving from another visa route and have been working for you for 3 months. You need to put a statement in the box when you're applying for your allocation of certificates of sponsorship to confirm that that is the case. You also need to provide the name, nationality, and date of birth of each individual that you're going to be assigning a certificate of sponsorship to. You're no longer able to ask for an allocation of certificates where you haven't identified the individuals that need them. And where they were previously sponsored, ideally you should be providing a copy of their previous COS reference number. Where you're not providing these things, increasingly what we're seeing is that UKVI are rejecting your application for your COS allocation increase. So really important that you're adding these into the box of supporting information when you're making that application. So yeah, that deals with the problematic area of certificates of sponsorship. We'll move on to right to work checks now. So right to work checks are used to ascertain whether someone is an illegal worker. So an illegal worker, importantly, is not only someone who doesn't have permission to be in the UK, including overstayers, it's also someone who doesn't have permission to do the work in question. So they might have permission to be in the UK, but they're not allowed to do the work that you have offered them. So right to work checks should be carried out before an employee has commenced work for you. If you delay in carrying out right to work checks, there's a risk that you could be illegally employing that worker. And even if you're not illegally employing them, it turns out when you've done the right to work check that they are eligible to work in the job that they're doing. If you've delayed in carrying out that check, UKVI can still deem that you're a risk to immigration control and may revoke your sponsorship license because of that. So really important to do the right to work checks before employment has started. Also to note, the right to work checks must be carried out for all staff, not just those requiring permission to work in the UK. So you need to be carrying out right to work checks for everyone. So what do you need to do to carry out a right to work check? So you must carry out right to work checks on all prospective employees before employment starts, as I say. You need to carry out follow-up checks on employees who have time-limited permission to live and work in the UK. You need to be keeping records of all checks that are carried out. And overall, you need to be not employing anyone that you know or has reasonable cause to believe is an illegal worker. And the reason for this is that there are really steep penalties if you're not complying with these rules and you do employ someone illegally. So if you have employed someone who doesn't have the right to work, there is a £45,000 fine per worker if it's your first offence, or that increases to a £60,000 fine per worker for subsequent offences. I see we've had a question raised as we're doing with this, so thanks for popping that in the chat. So how often should we do right to work checks? Now, really, to comply with the rules, you just need to do it before employment has started, and then once you've essentially assigned a new certificate or they've got a new visa, if they're time limited, if they're subject to time limited stay. However, what UKVI advises is that for best practice, you should be doing it every 6 months. So that's when you should be. That's how long they recommend, but that's best practice essentially. As long as you've made sure before their employment and then after their permission has ended, and once they've applied for new permission, that's when you should be checking it again. So hopefully that answers the question. Feel free to unmute as well if you want to ask a question as well, rather than popping in the chat. I'm happy to deal with either. Other sanctions then, as well as these other penalties, are that your business could be closed temporarily and a compliance order issued. If you're a director of the business, you might be disqualified. Your sponsorship license might be revoked, and so you might not be able to sponsor workers. And your earnings made as a result of illegal working might be seized. And then if you knew or had reasonable cause that someone didn't have the appropriate immigration status and still went on and employed them anyway, that can amount to a criminal offence, and the sanction for that can be a prison sentence of up to 5 years and an unlimited fine. So that's where something is done on purpose. So again, really serious consequences there. Someone's got a hand up.
Yeah, thank you. I was just going to ask, can someone, a supplementary worker whose sponsor license has been revoked, can they continue working during 20 hours with another employer?
Yeah, it's a good question. We're going to come to that in a bit more detail later. You've jumped the gun a bit, but no, good question. What I'll do, I might just wait on that one until we cover that on the slides, and then if you've got any questions following those slides, would you mind asking it then?
Yeah, of course. There was another question relating to the 10, 15 years.
Oh
I
yeah.
was going to ask those that are already here since from 2022, are they also part of the group for the
We
10,
don't.
15 years?
Yeah, we don't know yet because the rules haven't been announced. I'd be surprised if they weren't. I my my expectation is that anyone who hasn't yet qualified for indefinite leave to remain or hasn't applied for it will then be required to comply with the new rules. It won't exclude everyone who's already in the country, unfortunately. So yeah, even for people in the country, I think they'll have to comply with those new rules, but it's going to be a case of waiting and seeing at this point.
Thank you.
No problem. Thanks for the question. Okay, perfect. So moving on, how do we carry out right to work checks? So to comply with your right to work obligations, you need to carry out the following checks on each employee before they start work. So it's either a manual right to work check. Obviously, that's going to be less applicable for international workers now. You can carry out an electronic right to work check via the services of a digital identity document validation technology provider. So if that's for British and Irish citizens, generally not needed. You can generally just get the passport or the birth certificate of them, and that'll be sufficient for their right to work purposes. But if they don't have that, you do have that option available. Or you can carry out a Home Office online right to work check. Obviously, that's for your sponsored workers. That's through the e-visa and the share code that they generate through that. So that's generally what you'll do for your sponsored workers now. As I mentioned before, you've also got the option to do an employer's checking service check, say where they've got an ongoing visa application. You can plug in the application reference number of that, and where they've got a valid application, you'll usually get a 6-month extension to the right to work whilst that is ongoing. But yeah, otherwise, generally, the normal right to work check, the normal online right to work check will apply. So there's 3 steps you need to follow to do your right to work check. The first is to obtain evidence of the right to work. So as I say, for workers requiring immigration permission, that'll be through the online right to work check using the share code provided via their e-visa. Otherwise, you'll be following the other right to work checks under List A, List B of the rules. Again, it will normally be just passport and birth certificate for List A people, those people who don't require permission to be in the UK, that will need to be done. Now, the second step is to check. So importantly, this needs to be carried out in the presence of the employee, either in person or via a live video link. John, did you have a question?
No.
No, okay, no problem. That's fine.
No.
If you just want to go back on mute,
Yeah, sorry.
that'd be great. No problem at all. And yes, as I say, that needs to be carried out in their presence. Really important to check the box as well on the online right to work check to confirm that. We do a lot of mock Home Office audits, and the number of times I've inspected right to work documents for providers, and they've not ticked the box on the right to work checks to say that they've been carried out in the presence of the employee or otherwise indicated that they've been carried out in the presence of the employee. And if that's not done, then that's likely going to be deemed to be non-compliant by UKVI and may well result in your license being suspended. So really important to, if you've not done that, go back and check those boxes, and that'll make sure those checks that you've done are correct. Step 3 is to keep copies of those documents. So those documents should, if they've been manually checked, you should keep the hard copies and record the date of the check and the date of follow-up checks. Or for online checks, it'll be the profile page that is generated on the online right to work check, and that includes the individual's photograph and the date on which the check was conducted. Now, again, really important that you press the print this page button on that profile page, and either save the PDF of that or print it and either keep the hard copy or scan in the hard copy. It's not sufficient for you to be taking a screen grab of that profile page or for you to be keeping a copy of the URL for that. Again, that's going to be non-compliant, and that may well result in your license being suspended. You need to ensure that you're keeping the proper printout of that profile page, either on PDF or printed. Again, I do see a lot of that when doing Home Office audits, and it's a pretty widespread problem. And then finally, it's a case of retaining those documents. So you need to keep them securely. So if they're on your computer systems in a password protected file or in a locked filing cabinet, if it's hard copies, and they need to be kept for a further 2 years after the worker stops working for you. After that point, you can securely destroy those files. So again, really important to make sure that you're keeping those for 2 years after employment ends. There are problematic areas when it comes to right to work. We'll have a look at supplementary hours workers in a moment, but the other more problematic area is in relation to students. And this is because students, they require an extra hoop for you to jump through when it comes to proving their right to work. So international students are permitted to work in the UK for a limited number of hours during term time, and that's usually limited to 20 hours a week. They can also work full-time before their course starts, during vacations, and whilst they retain permission after they've completed their course. And this permission to work is usually set out in their e-visa. So as well as doing your normal right to work check using their share code, you also need to have kept copies of their academic term and vacation time. So this should be confirmed by their course provider, and you need to keep a copy of that letter. Also really important, you diarise that because you need to be making sure that that student doesn't do more than that 20 hours a week during term time, because if they are doing more than that 20 hours a week during term time, even if it's a once off, that's going to be deemed to be illegal working, and that may land you with one of those significant fines. Also to note, students not permitted to fill permanent full-time vacancies unless they're applying to switch into the skilled worker or graduate routes during their study. So they can have a temporary full-time vacancy, say during a vacation period, or they can have a part-time or a variable hours vacancy, which takes into account term times. But otherwise, they can only do a full-time vacancy up to 3 months prior to their course completion if they're moving into the skilled worker route, or once they've successfully completed their course of study if they're moving into the graduate route. Now, as I said, the other problematic area that we see is supplementary hours, and we'll have a look at that in a bit of detail because obviously it's pretty widespread, the use of supplementary hours in the care sector. So something that if, a lot of you will be taking advantage of. So essentially, for someone to be eligible to work supplementary hours, the worker must continue to work for their sponsor in the employment specified in their certificate of sponsorship. So the first thing you need to be bearing in mind when someone's coming to you for supplementary hours is, are they still working for the company that sponsored them? Now, when it comes to the job that they're fulfilling for supplementary hours, it needs to be at an eligible occupation code that is at a higher skilled job. Those are RQF level 6 or above. Or it needs to be one that appears in the appendix immigration salary list. So that includes care worker and senior care worker. Or it's in the same profession and at the same professional level as the job for which the individual certificate of sponsorship was assigned. Now, just to note that supplementary employment is only permitted in a job listed as medium skilled. So that's below RQF level 6. If the worker was issued a certificate of sponsorship for their skilled worker visa before the 22nd of July 2025 and their immigration permission has not lapsed during that date. Now, that's not going to apply to care worker and senior care worker roles until the end of the transitional period at the moment, because they'll still remain in the appendix immigration salary list. But when they're removed from that, if you've got someone who wants to do supplementary hours and who haven't previously been sponsored as a care worker, then they're not going to be eligible for that supplementary work. Jay, did you have a question there? No, that's fine. That just coming off mute. That's not a problem.
There's a couple of questions in the chat, Ed. So
Yeah, I'll
we'll
have a look
back
at
to
those.
those.
So
Yeah.
I see that Evelyn's asked a question. Are we required to keep copies or screen grabs of staff e-visas? You can do. It's not necessary to prove their right to work. It's just a case of doing the right to work check. So you can do, but yeah, not something that you need to do. James has also asked, do you know if sleeping hours are included in the 20 hours limit? So that's something we're going to be looking at in more detail in our next webinar. So we're going to be having a look at salary and what constitutes salary. So we will have a look at that in a bit more detail then. It's a fairly complex issue. To summarize, it's not considered to be working time under the working time regulations in a lot of cases. However, there is a danger that we've seen that UKVI case workers are considering that it should be paid as working time. So the general advice is that if you've got someone who is sponsored or is undertaking supplementary hours, ideally they shouldn't be doing sleep-in shifts because you are running the risk that you are underpaying them for that in the eyes of UKVI. So that's the sort of brief advice there, but yeah, more in depth. We'll have a look at that next time. So please do come along to the next session. And Evelyn's asked another question. If someone has a COS for 6136, can they work 20 hours for 6135? Yeah, absolutely. That's absolutely fine. Again, because they fall within that eligibility period that we see here. They're in a role that appears on the appendix immigration salary list, the role 6135. So yeah, it's fine to give someone supplementary hours under that. Okay, perfect. Thanks for the questions. So I think we finished off there. Yep, we finished off there. So also to note, supplementary hours are capped at 20 per week, and that is a hard cap. So it can't be on an average basis, week on week. It's limited to 20 a week. So if someone works 10 supplementary hours one week, they can't then work 30 hours the next week. It has to be a maximum of 20, and that's in total. So if someone works for numerous people giving them supplementary hours, it's only a total of 20 hours a week that they can work. It's not 20 for each supplementary employer. Also, supplementary hours cannot be provided within the hours that a worker is contracted to work for their sponsor. So you need to provide supplementary work outside of their usual working hours. And where supplementary employment is permitted, it doesn't need to be with a licensed sponsor. So you don't need to have a sponsorship license to be providing someone with supplementary hours. Sandra's asked, whose responsibility would it be for checking that they are working no more than 20 hours? It's a good question, Sandra. Essentially, this is really down to the worker. So if they're working for you doing supplementary hours, then obviously you need to be making sure that they're not working more than 20 supplementary hours for you. If they're working more than 20 supplementary hours for you, that's going to be deemed to be illegal working. And again, you might face that £45,000 fine per worker. If they're doing supplementary hours for someone else, as a supplementary employer, you're not expected to keep track of that. But if you do become aware of it, then you need to be essentially stopping employing them at that date because you know that they're in breach of their visa conditions. But if it's an individual and they're sort of undertaking various 20 hours for various supplementary employers, and those employers are none the wiser, then it comes down to the individual. It'll be their visa that is cancelled because they're in breach of their visa conditions. As a sponsor, again, you're not expected to keep track of the supplementary hours that a worker is doing, but if you become aware of it, again, you're likely going to need to finish their sponsorship because they're going to be in breach of their visa conditions. And if you're not doing that and you're aware of them being in breach of their visa conditions, a UKVI might deem you to be a threat to immigration control and you're risking your sponsorship license. So hopefully that answers the question there. We got another question. Can supplementary workers continue to work if their original sponsor license has been revoked? Yeah, absolutely. We are coming to that slide. Honestly, we will be getting to that. So we'll have a look at that in a bit more detail in a moment. I promise I will get to that subject. Perfect. So right to work then for supplementary employment. So where you are employing someone for supplementary hours, in order to obtain the statutory excuse for right to work purposes, you're required to not only do the normal right to work checks for them, so do the online right to work check to check that they have the right to work. You also need to check that they're allowed to carry out the work in question, so they meet the requirements that we've looked at over these previous slides. What I would note here is that this second bullet point, that is deemed to be gold-plated best practice by UKVI. So this is to carry you do this to comply with the immigration rules, but UKVI are saying that their current approach is that they consider this to be going above and beyond, even though it is complying with the rules, and they'll generally not treat it as non-compliant if you are only doing the right to work checks for them, that you're not checking these additional things. So what the recommendation is that obviously you do want to be complying with the rules. So ideally you should be complying with these additional checks because, if UKVI do change their mind in future, you will be doing it correctly. So you won't need to change anything. But if you're not doing these additional checks at the moment, it's unlikely that you're deemed to be non-compliant. So to do these additional checks, to get this additional evidence, what UKVI recommends is that you ask the worker to provide a letter from their sponsor confirming that they're still working for their sponsor, confirming the job description and occupation code of their sponsored employment and their contractual working hours. Now, we know in practice that it's usually really difficult to get any information from a sponsor, so there are ways around this. So the way you get around this is that you ask the worker to provide a contract of their employment with their sponsor, because that will confirm the job description. So you can check that the occupation that they're sponsored for is eligible for supplementary employment. It may also confirm their contractual working hours. If it doesn't, you can ask for a copy of their recent rotas, because that will confirm their contractual working hours, and you can make note of those and make sure the supplementary employment isn't given to them within those working hours. And you can also ask for copies of their recent pay slips, because those pay slips will confirm that they're still working for their sponsor. So that's how you get around that. Sandra's asked another question. Sorry, for those that are sponsored elsewhere for, say, a 44-hour per week contract, but then comes to us for up to 20 hours per week, would this be an issue? No, it wouldn't. I mean, if you're essentially, if you're employing them for 20 hours, that'll be fine. For their sponsor, it may be an issue because they'll have needed to opt out of the 48-hour working week. So if you're aware that someone's working more than 48 hours, you should be getting them to enter into a 48-hour working week opt out to avoid any issues with the working time regulations. If you've not done that, then yeah, that's where it might be an issue, and you'd need to ensure that they're not exceeding 48 hours. So yeah, that's the only thing to look out there for there, Sandra. Otherwise, yeah, not an issue otherwise. Perfect. I will be coming to the revocation question on the supplementary hours. Okay, great. So in practice, that means that it's common for staff seeking supplementary employment to be no longer working for their sponsor. In those cases, you should not be providing it. So, as I say, that's the key question you should be asking yourself. They're no longer working for the company that's sponsored for them. They're not eligible for supplementary hours, so you shouldn't be providing this. If you become aware that the individual's no longer working for their sponsor whilst they're working supplementary hours for you, you lose the right to work statutory excuse at that point. So you should stop providing them with supplementary hours. If an individual's right to work check, that still may state that they have the right to work even where they're ineligible for supplementary hours. So that's why ideally you should be doing these additional checks that we just had a look at to check that they're eligible. And even if you don't have knowledge of, but only grounds to suspect that the worker is no longer working for their sponsor, you should request further information from them and or their sponsor at that point. And if you identify that a worker is acting in breach of their sponsorship requirements or their visa requirements, you should take steps to terminate their employment and consider whether it's appropriate to report it to the Home Office. In most cases, it will be, because obviously that shows that you're not a threat to immigration control. And as I say, unofficially, UKVI are not actively enforcing non-compliance in relation to supplementary hours at this time, but are likely to do so at some point in future. So the sooner you're complying with best practice when doing these right to work checks, the better. Now, dealing with license revocation and the changes that we've seen here. So what we've seen recently is that following the revocation of a sponsorship license, UKVIs have changed the wording in the license revocation letters that they're sending out. So what they used to say in these letters was that the company was no longer eligible to sponsor workers and could no longer issue certificates of sponsorship to them. What has changed is that these letters now say that the company is no longer able to issue new certificates of sponsorship. And what UKVI has confirmed is that where a license has been revoked, that company can still continue to employ those sponsored workers until their right to work ends. So either their visa finishes or their visa is curtailed. So those workers can now continue working for a company whose license has been revoked. And as long as they're working for that company, even though its license has been revoked, they will remain eligible for supplementary hours because they are still working for that company. So again, just to reiterate the key question is, are they still working for the company that sponsored them? Whether or not that company still has its license or not is immaterial. It just matters that they're still working for that company. So that's the question that you'd be asking there. So hopefully that answers the questions about eligibility for supplementary hours where a license has been revoked. Now, just a few recommended clauses where you are employing people for supplementary hours. What we generally recommend is that you have a clause in there that they have to seek permission from you before they start working for another employer aside from their sponsor. This just helps you keep track on if they're working for other supplementary employers. And if you're aware of that, then that may well lead you to ask questions about, are they working more than the 20 hours that they're allowed to? You should have a clause in the contract where they're required to notify you immediately if there's any changes that might affect their working hours with their primary employer, because obviously that might affect the hours that you can provide them with supplementary employment. If there's any changes to their sponsorship, their right to work or visa status, because again, that might affect their eligibility for supplementary hours. So if you've got a clause in there requiring them to inform you of that, if they don't, then you can point UKVI to that and say, well, look, we tried our best. We did all we could to ensure that they would inform us of that, but they've hidden it from us. Ideally, you should have a clause in there that their employment is contingent on them retaining the right to work in the UK and continuing to be employed by their primary employer, because that's obviously required for them to be eligible for supplementary employment. And also, if driving is a requirement for the role, that their ongoing employment is contingent on having a full driving license that's valid in the UK. So these are recommended clauses for supplementary hours employers. Jay's put a question in the chat. Thanks for the question, Jay. We've come across a lot of agency workers on supplementary work, and we found that they were no longer working for their sponsors due to license revocation. But the agencies they work for say they have a right to work. We explained that their right to work is on the condition that they have a live sponsorship. We have declined such workers, and we now ask to see their COS so that we can check their employers on the register of licensed workers. Yeah, it's a good point. As I say, when it comes to license revocation, as long as that individual is still working for that company that sponsored them, they are still eligible for supplementary hours. So that company may well not appear on the register of licensed licensed sponsors because their license has been withdrawn. But as long as those workers are still working for it, they'll be eligible for supplementary hours. So you may want to be asking for those individuals for copies of those pay slips with that company just to make sure that they're eligible for supplementary work. That would be the way that you check that, rather than maybe checking the register of licensed sponsors. But essentially, you're not obligated to provide anyone with supplementary hours. So if that's the way that you want to check and make sure that you're not employing them illegally when it comes to supplementary hours, that's entirely your choice. That's not a problem at all. Just quickly then, dealing with clawing back costs, because that is another problematic area that we see when it comes to compliance. Hopefully you're all au fait with this. I think most providers are pretty on top of this now. It was problematic at the start of the health and care worker visa, but I think we're all generally good on this. But there are limits on what costs you can claw back from sponsored workers when their employment ends. So you can't claw back the cost of the sponsorship license because that's something that you as a business benefits from, not the individual. You can't claim back the immigration skills charge, but obviously you can fully or partially recover that from the Home Office. Technically, you can recover the cost of the certificate of sponsorship, but as we'll see in a bit, it's in breach of the CQC Code of Practice on sponsoring international workers. So you'd be in breach of CQC regulations. So that would be a CQC problem. If you have loaned or given someone money to pay for their visa fee or immigration health surcharge, if it applies to the role, then yes, you can claw that back. There are other costs you can claw back, such as if you've made a loan or if there's costs for service occupancy, but generally that should be dealt with in those documents relating to those. So in the service occupancy agreement or the loan agreement. Jay has just added a clarification for his previous question. The issue is that when a company loses their sponsorship license, UKVI do not automatically have the workers' right to work updated. Yeah, I mean, Jay, the issue is that even where a company loses their sponsorship license, it doesn't necessarily mean that the worker's not eligible for supplementary hours, as we saw in that previous slide. Workers continue to be eligible for supplementary hours as long as they're working for that sponsor. So maybe the company's lost their license, but they're still employing those workers. So in those cases, the workers would still be eligible for supplementary employment. Hopefully that helps answer the question and clarify that point. So issues to consider when you're clawing back costs. The deduction from wages needs to be authorized. So even if you are legally able to recover the cost that you're looking to claw back, if it's not authorized in writing by the worker, you can't do it automatically. You would need to go through the courts to do that. So what you should be making sure is that you have a clause in your employment contract that says that the worker authorizes you to deduct any amounts that they owe you at the termination of their employment from their final pay. Otherwise, to deduct any wages from their final pay, you would have to get them to sign something in writing for you. So better to have it in the contract so you don't have to worry about that. You also need to consider whether it's a restraint of trade or amounts to modern slavery. So this is where the costs that you're looking to deduct are so high that they essentially prevent someone from leaving your employment and being employed somewhere else. So if there are substantial costs to be deducted at the end of employment, yeah, you need to be bearing in mind whether you can actually claw those back, and that's something you should be bearing in mind when it comes to say loans you're giving, other amounts that you're providing to workers. Consider that if taken together, when it comes to the end of their employment, that those amounts, if they have to be repaid, essentially stop them leaving, then that's going to be an issue for you. Discrimination, that just matters if you're essentially charging people different amounts depending on, say, their nationality. That's obviously something you shouldn't be doing. And then whether it's a penalty clause. So if you are looking to recover some, so say, if someone doesn't return their uniform, that you're recovering a sum for that. It should be a genuine reflection of your losses. So you shouldn't be charging, 100 quid for not returning a uniform. That's not going to be a genuine reflection of your losses. That will likely be deemed to be a penalty clause. It'll be unenforceable. So you should just make sure that any sums you're recovering do reflect the amounts that you've actually paid or that you'll have to pay to deal with that. Now, the CQC Code of Practice, I won't go through this in too much detail, but it's here on the slides if you need it. Essentially, this is the 4 principles that you need to comply with when you're clawing back costs from sponsored workers. So the cost you're clawing back should be transparent. So you should be upfront about those when employment starts. They should be proportionate. So they shouldn't be more than, as I say, the losses that you're suffering. There are other restrictions on the costs that you can look to recover. So those are listed here, and they include the certificate of sponsorship, which otherwise wouldn't be prohibited from being recovered. Timing wise, they should taper off. So say you've got upfront costs that you've incurred, say for onboarding training for sponsored workers. These should be tapered during employment, because obviously you get more benefit from that individual having had that training the longer that they're employed with you. Over a period of, say, 3 years, those costs should taper on that basis there. And then finally, where an individual is leaving due to certain specific circumstances that's outside of their control, you should be considering whether flexibility should be granted when it comes to repaying those costs that you're looking to recover. And that takes us on to UKVI compliance visits. As I said at the outset, UKVI taking a more active approach to non-compliance. So that's resulting in more inspections and harsher approaches to non-compliance, usually revocations of licenses. So really important that you're up together with your sponsorship compliance. Now, visits can be announced or unannounced and can occur at any time, but common triggers include a sponsorship license being granted, a change to your address, if you've been involved in a takeover, merger, or a TUPE transfer, or if you've established a new branch. Any of these can increase the risk that you're going to face a UKVI compliance visit. And compliance officers estimate that it takes around 2 or 3 hours to carry out a visit, an inspection of your business. So during that time, some of the things which will be checked include that sponsored workers are fulfilling the job vacancies at the correct skill level, that you're keeping the required records to fulfill your sponsorship duties, so obviously your right to work checks, etc. That you're paying the migrant at least the minimum salary rate, so they'll want to see pay slips and working records, etc. That the right types of certificate of sponsorship have been issued, and if you have an annual allocation, whether that's still justified. That the information you provided in your sponsorship license is accurate. That'll generally be if the inspection is triggered by a sponsorship application. The migrant is complying with the conditions of their leave to remain in the UK, so they'll likely want to interview the migrant workers as well, and that generally you're not a threat to immigration control. So some practical tips that you should be bearing in mind if you're preparing for an inspection. They'll want to see a floor plan of your premises. This should be a more detailed one than, say, a fire escape plan. This should be either the lease plan or the official copies plan. They'll want to see a detailed plan of the premises. Have you taken copies of right to work paperwork correctly? We covered this in a bit of detail before. So have you ticked the boxes correctly? Have you printed the checks correctly? If not, you should be doing that to make sure that you're prepared. Are the photographs and dates of birth consistent across documents and with the person's appearance? So have you, again, done the check in someone's presence, checked that their photograph complies with their likeness, and have you checked that box? Are you securing right to work paperwork correctly and securely? Are you holding it for 2 years after employment has ended? Can you show for your leavers who have left within the last 2 years that you've got right to work paperwork for them? Have you got a system which flags up right to work permission? And can you show the expiry dates for this haven't passed? And can you contact overseas staff at short notice? Have you got up-to-date contact information for them so that you can call them for an interview with a compliance officer? So what happens after a compliance visit? So a visit report will be completed to the caseworking team and a recommendation provided by the officer. This will be that you'll either keep your A rating to say that you're doing everything right, or that you'll be given a B rating. So following a B rating, you'll usually be required to pay a fee and accept an action plan. If you don't accept the action plan or decline to pay the fee, then generally your sponsorship license will be revoked. If there's anything more serious, then your license may well be revoked without suspension. So when it comes to enforcement, as I say, a change of approach between suspension and revocation. Generally, there are more revocations now without suspension, particularly for breaches relating to pay or reporting duties. Dealing with suspension. So this is, well, historically, this was usually the first step that UKVI would take where someone hasn't complied with their sponsorship duties. If your license is being suspended, UKVI will write to you, notifying you that your license has been suspended. They'll identify the areas of concern that have been identified. They'll set out the remedial action which you should undertake, which will include a list of documents which you'll need to send to UKVI. And they'll give you a date by which this needs to be done. And that's usually within 20 working days of the date of this letter. So not a lot of time. So if your license is suspended, it's usually a good idea to get urgent legal advice to help you with your response. The suspension will usually last for around 8 weeks from the date of the suspension letter. This allows you time to give your response and also for UKVI to give their final decision. And whilst your license is being suspended, you're not permitted to apply for any further COSs, and your business will be removed from the public register of sponsors as well. Now, when it comes to revocation, as I say, suspension is usually the starting point unless there's something particularly serious. There are mandatory grounds for revocation, and that's set out in the link here. So if you're particularly interested in trawling through those, you can do so when you get the slides. And again, there are non-mandatory grounds as well. If more than one of those applies, then that will usually result in revocation without suspension too. And again, there are details of those in the slides. If your sponsorship license is revoked, there will normally be a cooling off period of 12 months applied before you're able to apply for a new one. So from a practical perspective, if in the worst case scenario, your license is revoked, you obviously have a decision to make. You've got the option of essentially, sucking up the decision and waiting 12 months before you then apply for a new license. We know at the moment that UKVI is allowing you to continue to employ your sponsored workers until their visas are expiring either through general expiry or curtailment. So if no one's visa is going to be expiring during that 12-month period, you could say take the risk that their visas aren't going to be curtailed, or that you're going to be able to deal with any curtailments by taking advantage of agency workers or supplementary hours workers, and that you can ride out that 12-month period. So that is a valid approach for you to take. The other option is judicial review. Now, judicial review, it can be lengthy and expensive. What we are seeing is that there is quite a lot of success in getting license revocations overturned at the moment in the pre-action phase. So where we would say send a pre-action letter to the Home Office to say, well, look, the decision was overly harsh, or that it's going to have an overly harsh effect on your business. They'll often overturn the license at that stage without proceedings needing to be issued. However, if proceedings are needing to be issued, you need to bear in mind that it's a lengthy and expensive process to get to a final hearing, overturn a decision. You're looking at sort of £20,000-30,000 to get to a final hearing when it comes to legal fees. So not something to sort of have to do lightly. So that's your two options there, really, if your license is revoked. So ideally, you'll be compliant and you won't find yourself in that position. And that takes us very nicely to 10 minutes. If there are any additional questions, if you do have a question, please do let me know. Either pop it in the chat or come off mute and raise your hand. Happy to answer anything that anyone may want to ask.
Ed, I just want to add in, I've heard recently about when people have had UKVI visits, the importance of checking the ID of the person who's coming. So it sounds like there have been incidents recently where people who are not from the Home Office are coming to say they are from the Home Office to gain access to people's computer systems, particularly like the sponsorship management system. So as you would with CQC, and particularly if it's an unannounced visit from the Home Office, check who is coming. The Home Office are happy for people to phone the Home Office and ask, is this a genuine worker?
Yeah, really good point. Same with anyone, I guess, is sort of increasing these days, isn't it? Gas inspection engineers, anything. Yeah, you need their ID because particularly for you're in a very data sensitive sector. So yeah, really need to be making sure that anyone who is coming onto your premises is who they say they are.